Well, hello, and welcome to the Employment Law Show. We're back for another episode. So good you can join us. John Scholes here. Beside me, of course, Lior Samfiru. You want to reach out to Lior anytime. I always give you the contact information right off the top. 1-855-821-5900. help@employmentlawyer.ca. And do not forget about that website. It was constructed by Lior and his team just to make you that much smarter about employment rights and workplace law. And it's called pocketemploymentlawyer.ca. Beyond all the stuff you can learn about, kind of a small version, a quick version of what you learn about on the show every week, right? But you'll have access to the severance pay calculator, which is super handy. We'll use it, take it out for a spin, as we say, a couple times during the show today. But again, pocketemploymentlawyer.ca. And the main topic, what you need to know about taking a stress leave. That's coming up a little later on the show. But as always, pal, we always start off with the case of the day or a week that was, something you want to chat about off the hop. What do you got?
Hey, John, awesome to be here, of course, to talk about employment law, to try to solve so many workplace problems and inform our good viewers on this very, very vital, important topic. If you have a job, you need to understand employment law. If you're working, you need to know what the law does for you. So you don't have to guess, so you don't have to try to go to Google and figure it out or ask your cousin Joe who maybe worked at HR for a few months. No, we need to tell you what the law really does for you because you have extensive employment law rights. We have some of the best employment law rights in this country. Unfortunately, not too many people understand what those rights are. Well, this is the show that evens out the matters, that tells you what you need to know, that gives you the truth. Whether you lost your job and you're staring confused at that severance package, maybe you're in a situation where you've been given an ultimatum. You better accept this job change or else. What does that mean? Can they do that? How to respond to it? We'll tell you. Or maybe it's simply a situation you're not being treated properly and you want your boss to do something about it. How can you make that happen, and what happens if they don't? We'll tell you all that and much, much more. But of course, this is a 30-minute show. Beyond the show, you can reach me in the office. We'll keep giving you that contact information throughout the show so we can have a private chat about your specific situation. But now that we know what we want to do, let's do it. Let me tell you about a situation that came across my desk. This one may not be that interesting, but it's kind of funny. I think you'll get a bit of a kick out of it. I spoke with a very nice lady who unfortunately was let go because of restructuring at her work. She was called into a meeting, was given her severance package, and she was told this: well, we are so sure that our severance package is good that we'll pay a few $100s for you to have it reviewed by a lawyer. And by the way, we recommend this Lior Samfiru guy that we see on TV. It seems like he knows what he's doing. You should actually go see him and see what he says about your severance package. So she says, okay, that sounds good. I mean, they'll even pay me to do that. I'll go see, by the way, it's Lior, not Liar. And she comes to see me. Now, this lady had worked for her employer for a year and a half, and she was offered 6 weeks severance. She was in a more senior role and a bit older. Well, guess what? The 6-week severance that they offered her, not even close to being adequate. In fact, she was owed about 4 to 5 months of severance. So probably 3 times what her employer offered her. So all of a sudden, this employer is probably not going to like me anymore as much as they did, because they thought, hey, after a year and a half, we're being generous. 6 weeks after only working for a year and a half, not so fast. Remember the rule. Short service employees get even more severance, or disproportionately more severance, than longer service employees. So that severance offer is terrible. The lesson here, though, is interesting. Number one, as I said, you're probably owed more than what your employer is offering you. But beyond that, whether you work for a big company, small company, good company, bad company, the rule still applies. Whatever you've been offered, it's probably less than what you're owed. You have to give me a call so that you don't accept less than what the law says you should have.
I don't think you guys are sponsoring the company barbecue this summer. I think you're off. I think you're off the list. But
yeah, I'm off the list. But I can only be honest. I can only tell the truth. And in this case, she was owed a lot more.
And this isn't a freak occurrence, what she was offered. That's a very common thing you see all the time as far as the math is concerned, right?
Well, if we went for a walk on the street now and we asked the people, hey, someone was let go after a year and a half, they were offered 6 weeks severance. Do you think it's good or bad? I bet you 80%, 90% of them are going to say, that's great. 6 weeks is fantastic. Well, obviously that's what the company thought as well. But it's not. That's not what the law provides. The law will treat a short service employee even better potentially than a long service employee. For her, that means 4, 5, even 6 months of severance. So that's why it's so important to do the right thing, to call me and get proper advice.
We often we talk about as well, Lior, did they include all components of the severance package if she had any bonuses or stuff like that? Was that in there as well? And is that common as well? You have to include everything?
It has to include everything. And in this case, they actually didn't continue benefits for as long as they should have. So remember, benefits has to be continued for the severance period, whatever bonuses, commissions that you usually earn, pension contributions, that could be a big thing. All components of your compensation have to be included for the severance. So it's not just how many months you're going to get paid. It's also what's included in it.
And as Lior always says, always reach out if you want to reach him and a team. If you've got a similar situation or anything else, really ask some questions. Won't cost you a dime. That's 1-855-821-5900, help@employmentlawyer.ca. Now, if you go to employmentlawyer.ca, the website, on the media tab, you'll be able to find a radio station close to you across the country and, of course, here in the GTA as well. Catching our weekly radio show, which this past weekend just turned 11 years old. 11 years old. We've been doing that, Lior, a long time. Thousands upon thousands of people have helped, had their eyes opened up about, wow, I had no idea I had those type of rights, which is why we do this every week. We got a lot of good phone calls coming in on the show as well. Feel free when you're listening to the radio show to take the number down that I gave you, a call into the show, and maybe your call will appear on air, just like this one that we're going to get to right now.
I was just served notice by my employer. She claims the company is closing down. So when I asked her if she could please provide the letter of termination in writing, to which she said, I'm entitled to nothing more than the 3 weeks notice. I'm turning 63 on Monday, so I worked there for just under 4 years.
3 weeks and...
Exactly.
Yeah.
And listen, I will give this employer the benefit of the doubt. This employer may actually believe that all this employee gets after 3 years is 3 weeks notice. Well, guess what? That's not true at all, not even close. Now, whether the company's closing down or whatever the reason is that this lady is losing her job, she's going to be owed a lot more than 3 weeks. Now, she made an interesting comment there that because she's in her 60s, it's going to be a bit more challenging to find another job. Well, that's why older employees get more severance, because you need that extra money to carry you until you find another job. So age is an important factor. So we know that this lady is owed a lot more than 3 weeks having lost her job. How much more? Well, for that, of course, we're going to go and use our severance calculator tool. You can find it and use it yourself at pocketemploymentlawyer.ca. And let's do that right now. Let's see what that gives us. So we know that this lady was in a professional role, been there right around 4 years. She said she's 63 years of age. Her employer says, we're going to give you 3 weeks notice. Well, you can see that she's owed 8 to 10 months. That's not weeks, John. That's 8 to 10 months of severance that she's owed. So I don't even know what that is. That's probably 20 times or 15 times, whatever it is that she was offered by her employer. That's exactly why it's so important to call me, to use the severance calculator. Of course, you'll find it again at pocketemploymentlawyer.ca. You don't want to find out after the fact that you're owed 15 times what your employer's paid you.
And you mentioned being 63 with the aging workforce. That component of measuring severance is going to get more and more broad as we continue on, right? Everyone's getting older.
Absolutely. Everyone's getting older, and there's going to be an impact on severance, of course. And the older employees, and by the way, I see employees are working beyond 65, into their 70s and even beyond. And that means you get more severance. So you may have a short service employee or someone that's worked there for a few years only. If they're older, they could be looking at north of a year's severance. So very important to call.
Second phone call. Want to roll that right now? Again, we'll do the same thing. We'll talk about it afterwards, so have a listen.
A 77-year-old employee. Well, I think I'm an employee. I was working with a contract. Now my contract is up. I'm still working there. I asked for a small raise this year. They said I would have to negotiate, and they have the right to let me go without any compensation or severance. I've been with them for 23 years.
I remember that call. He's in his mid to late 70s.
That's right. And
Wow.
I remember that as well. So what I said to him is what I'm going to say right now is you don't work for a company for 23 years and not be an employee.
Right.
He's an employee. And what's important to remember here, of course, is because he has a job for 23 years, doesn't matter what the company calls him, the law says you're going to be an employee. That means you have the rights of an employee. For him, that means, of course, the right to get at least minimum wage, but also the right to get severance. Now, the company can let him go. The company he works for can absolutely let him go, whether we think it's fair or not. But they have to pay him severance. They may think, oh, he's a contractor. We can just end our relationship with him and pay him nothing. Not so fast. Because he's an employee, he's been there for 23 years and he's 70s, he's going to be owed 2 years' pay, the maximum severance that people can get. That's what he's going to get. Same with you at home. If you've had a regular job, then you're an employee. It doesn't matter to me, doesn't matter to you what the company calls you, what you think you may be, what you may have signed. If you look like an employee and act like an employee, you're an employee.
The phone calls on the show always come in threes. The third one is coming up, but we're going to do it after a short break. In the meantime, write down this number and email again to use it at your leisure to contact Lior and his team. 1-855-821-5900. Help at employmentlawyer.ca. We continue with more of the Employment Law Show coming right up. Don't go anywhere. People think you should go to the government to get severance pay. Employmentlawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at employmentlawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. Employmentlawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at employmentlawyer.ca. All right, welcome back, Employment Law Show. Good to have you along. John Scholes here, Lior Samfiru there. Reach out anytime, as you were advised to do, if you have any workplace problems or maybe a couple questions for Lior and his team. 1-855-821-5900, help at employmentlawyer.ca. And the website, anytime, super handy. Access to that severance calculator, which we're going to run through again momentarily. That is pocketemploymentlawyer.ca. But the phone calls, which we mentioned before the break, we always get 3 of them on this show. The third one, Lior, is coming up right now. Let's listen and then talk about it.
I was working for a company for about 7.5 months as a senior manager. I was let go just last week, and they've offered me 11 weeks' pay. They say that if I get another employment, they're going to pay out the remaining severance pay at 50% of the remaining amount.
How old are you right now?
54.
Give me a sense what your compensation level was.
175.
Okay, there you go.
Well, John, let's go take another walk outside and let's ask people out there. This person, after 7 months, only working for 7 months, he was offered 11 weeks of severance. Do you think it's good or not? And if we ask people, just randomly outside, they'll say, that's good. He only
Take it and run.
7 months, 11 weeks. Wow, that's 2.5 months or so. That's pretty good. Well, guess what? It's not pretty good. Remember what I said earlier. Short service employees are treated disproportionately better than longer service employees. That also applies if you only work for a few months. So what we're going to do again, because I want to show you how you can find out how much you're owed, whether you work for 7 months like this person or 27 years. We're going to go back to pocketemploymentlawyer.ca and use the severance calculator tool. And let's see what the real number is. All right, so we know that he's got a senior position, making good salary, about $175,000. Only been there for 7 months. Company says, here's 11 weeks severance. You see right there, he's owed 4 to 6 months of severance. Months. So instead of 2.5 months, he's owed as much as 6 months. And yes, that may mean that the period of severance that he gets is right around the same length of his employment. Remember, that's the rule. Short service employees, even only after a few months of employment, still have substantial severance entitlements. That's why you don't accept that severance no matter what, without checking pocketemploymentlawyer.ca, or better yet, giving me a call.
And as we mentioned before, components, he's a senior manager. There could be a car allowance, there could be a cell phone allowance, there could be a list of things that he's entitled to during that time, right?
It is very likely. Usually in a more senior position, you have several components to your compensation: incentive pays and bonuses and maybe stock options and car and phone, as you said. So all those components have to be included as part of the severance. It's not just your base salary. It's not just your salary and benefits. All of them have to be included. That's why it's so important to do this properly to make sure that not only do you get paid for the right period of time, but that everything that needs to be included is in fact included.
As mentioned, the main topic for the show today, what you need to know about taking stress leave. Number one, important stuff. You have a right to take unpaid stress leave if you have support from your doctor, from the doctor.
So this is the key here. That doctor, that's your ace in the hole. That's the most important thing for you to be able to take that leave. So your employer is not necessarily required to give you a leave if you say, hey, employer, I need to be off. But if a doctor says that, all of a sudden, yes, they have to. And because it's a stress leave, sometimes you may feel, well, I don't really want to share that with my employer. I don't want to tell my employer why I have to be off. Well, guess what? You don't have to. That doctor's note doesn't need to say for stress reasons or for mental health reasons. It simply needs to say that for medical reasons, you cannot work. You have a right to that privacy, and your employer can't make you tell them why. So you can maintain that privacy, and with that doctor's note, you can be off as long as you need to.
Second point, Lior, you need to explore the workplace if you're in this situation. You may be able to get either STD short-term or long-term disability benefits if you can't work due to stress or anxiety.
So many employees, through their benefits plan at work, may have a short-term and long-term disability plan. That means that if you cannot work and you don't have income because of that, then you can qualify for those benefits, and those benefits can pay you till 65 potentially if you need to and if your doctor says you're unable to work. Now, the same thing applies if the reason you can't work is for mental health reasons, stress, anxiety, etc. The law doesn't make a differentiation between a physical ailment and a mental health ailment. So your insurance company must pay you if you cannot work. If they don't, if they doubt you, if they don't listen to your doctor, you call us. We have a whole team just dealing with these issues exclusively. But yes, you should and you must, in fact, apply to those disability benefits if you have them. That's your safety net while you're getting better.
This third point, Lior, is quite often where employers they slip up a little bit, and that is you have a right to return to the same job and pay you had before you went off on the stress leave.
That's right. So just like your employer doesn't have the ability or the right to change your job whenever they want, they can't do that when you come back from a leave either. The expectation is that your employer is going to make all efforts to bring you back to the same job, same pay, same terms you had before you went off on a medical leave. If they've tried and there isn't another job at all for you, well, they can offer you something else, and if you want to, you can accept it, but you don't have to. That could be a constructive dismissal. If there's absolutely nothing for you, then they can let you go with severance. But they can't say, well, I've decided just to change your job, give you something else. Again, the rules with respect to constructive dismissal apply even when coming back from a leave. That means that if your job is changed, you may be able to treat that as a termination of your employment and get your full severance, up to 2 years of pay. But of course, and I've said this before you do that, before you tell your employer, no, this is a constructive dismissal, I'm gone, you call me. We want to do this right. We don't want to make a mistake in pursuing a constructive dismissal, so you call me first, and that's how we move forward.
What you need to know about stress leave and being off work for that, that's what we're covering in this show. One more point on this one, Lior. It is illegal for an employer to penalize or terminate an employee for expressing burnout or taking that stress leave, right?
Absolutely. It's a medical condition. It's absolutely a legitimate condition, and if you have that doctor's backup, you can't be penalized, you can't be threatened, you can't be fired because of that condition or because you're going to be off work or because the company thinks it's not legitimate. They can't question your doctor, they can't question how long you need to be off, and if they try to do anything other than work with you and accommodate you and do what your doctor says, that could be a human rights violation. That could be a constructive dismissal, not legal. So if your employer is not cooperating with you, understand that that's wrong. You have to give me a call. And by the way, often, just a letter from me, they just back off right away because they realize they made a mistake. So that's always an option.
More of your questions coming up on the other side of this break, which we'll take now. In the meantime, write this down again, the number and email to get a hold of Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. Lots more coming up in the employment law. She'll stick around. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. Employmentlawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at employmentlawyer.ca. And welcome back to the Employment Law Show. We'll continue on here. We mentioned the email, help@employmentlawyer.ca. Always have the phone number to reach Lior, 1-855-821-5900. But yet there was another way to ask questions anonymously as well. It's called terminationquestions.com, terminationquestions.com. You simply type them in and leave them. A member of Lior's staff will answer it and get back to you with an answer. Really simple and, again, anonymous, and you can do it any time on your cell phone, your desktop, or your tablet. Lior, for this week, I've been placed on an extended probation period by a manager despite no mention of this in my employment contract. If I'm let go in the next few months, would I be owed any compensation?
The answer here is very straightforward, and it's yes, you're absolutely going to be owed severance. And the reason for that is the only time your employer can let you go without compensation, without severance, is in the first 3 months of employment, and only if your employment agreement specifically says so. So if you sign an employment agreement that says in the first 3 months of employment, I'm going to be able to be let go without any compensation, that's okay. But if it doesn't say that, even in the first 3 months, you're going to be owed severance. But certainly beyond the 3 months, it doesn't matter. Once you go beyond the 3 months, it doesn't even matter what your employment agreement says. If you are let go, you're going to be owed severance. Now, we're going to be talking on a future show a lot more about probation and probationary periods. But what I want you to remember is that any probationary period that's longer than the first 3 months of employment, frankly, is meaningless, because you're going to be owed severance anyway. If it makes your employer feel warm and fuzzy by saying that you're on probation, fine. It doesn't actually do anything. So yes, will this person get probation because it was extended, or get severance because probation was extended? Absolutely, John.
It's funny because, you know, usually when you start a new job, and whether it's in the contract or not, if your boss or your employer at that time says, okay, so everything's good, we love it, it's going to be a good first day on Monday, but, you know, once we get through the first 3 months of probation, we'll rock and roll. Most people would just gloss over that and not even think anything of it, even if it's a verbal. It's not necessary. It's
not necessary at all. And by the way, if you're going to be accepting a job after you've been recruited from another job, right, I want you to run far away from a probationary period. Why would you accept a job or leave a secure job to accept another job only to be put on probation? Don't ever do that. Don't agree to that. If the company wants you so bad that they're recruiting you from another job, don't let them put you on probation. But otherwise, of course, remember that unless it's in writing, unless you sign an agreement that says 3 months of probation, you're not on probation. It's not automatic. And even if it is in that agreement, in many cases, we can still find ways to get around it and get you severance. So if you lost your job in the probationary period, whether it's the original probation or some form of an extended probation, I still want you to call me. You may be very surprised by your entitlements.
So if it says 6 month or 9 month probation after the first 3, it's like you're rearranging deck chairs in the Titanic. It makes no difference whatsoever.
It makes no difference. It's exactly what it is. It's not going to do anything. You're still going to be owed your full severance. So an employer that does that certainly probably doesn't understand employment law very well.
Right. Terminationquestions.com is where we got that question. Now, Lior does a ton of live streaming on YouTube and Facebook as well, at ST Lawyers. At ST Lawyers, if you want to join that particular conversation. We got a good one here from it. Lior this week says, I've been working part-time for the last 3 years. A few weeks ago, my hours were cut. To make up the difference, I took another part-time job. I'm now being told this is a conflict of interest. Can a part-time employer require exclusivity like this?
So this is a good question. So the answer is that an employer, whether it's a full-time or part-time employer, can expect you not to engage in conduct that creates a conflict. So if you're working for a competitor and by doing that, your employer's job or their business interests could be compromised, that's a problem. But let me give you an example where it's not a conflict. So if you work part-time at McDonald's and you also take a job at A&W, well, they may be competitors, McDonald's and A&W, but it's not a conflict. You're not going to be able to hurt McDonald's by also working at A&W. That's not going to be an issue, and an employer that says that's a conflict would be wrong. On the other hand, if you're a part-time programmer for Apple, but you're also doing programming for Microsoft, well, that could be an issue. There could be a conflict there. There could be confidentiality issues, and that employer, that original employer, may be very concerned about that. So if it's a true conflict, your original employer may be able to say, don't do that, and if you do, we'll let you go for cause. Otherwise, they can't do that. Now, even if it's not a real conflict, your employer can still let you go. What's the rule? The rule is your employer can let you go pretty much for any reason as long as severance is paid. So if your employer that you work for is not happy you work somewhere else, but there's no real conflict, they can still let you go with full severance, and that could be a very substantial amount. But the only time you can be deprived severance is if there's a true conflict of interest, and I think that will be rare.
The part in here I wonder, Lior, is where they say a few weeks ago my hours were cut. Is that where they could have dug their heels in right away and said, oh, crying foul, you can't do that?
That's absolutely right. That this person decided to replace that income finding another job, very proactive. But what they could have done and said, by cutting my hours, that's a constructive dismissal. You cut my hours, you cut my pay. I'm not accepting that. Instead, I'm going to leave, require you to pay me my full severance. Now, they didn't do that, so now they are deemed to have accepted this reduction. But for our viewers, it's very important to remember, if your hours are cut, you may want to say constructive dismissal.
Have you come across many contracts where exclusivities, it wouldn't be an issue if you're a barista in two different places, it wouldn't be in there, but fiduciary CEOs, is that very common?
So it's very common to see in an employment agreement a term that says you're not going to work somewhere where it poses a conflict of interest. And that's okay for any job. But beyond that, no, it's going to be tough to show just because you have a job somewhere else there's a conflict. It's not automatic, but if you're working for a competitor doing the same type of job and depending on your position, it can create a conflict or an appearance of a conflict, and that's a problem.
Again, you always forward that employment contract, whether it's new or old, to Lior. Let him have a look at it. help@employmentlawyer.ca. It's time for the Employment Law Show Rapid Fire. Strap in. Let's do it. Okay, here we go. I ask the questions, and luckily, Lior answers them. Number one on Rapid Fire for this week, Lior. Can your employer suspend you without pay?
The answer to that is no. Your employer cannot generally suspend you without pay unless you sign an employment agreement that says that, and most don't. So a suspension without pay in most cases is a constructive dismissal. You could be potentially suspended with pay if there's a good enough reason to discipline you that way. There's no right to suspend you without pay. Of course, we're talking non-union employees. And if you're suspended without pay, you may be able to say constructive dismissal. So you always want to keep that in mind.
Because without pay, you're already deemed as guilty.
Exactly. You're deemed as guilty. Yeah. And it's simply a term that's so extreme to put you off work without pay that the law says you can't do that.
Number two, can your employer ignore a doctor's note requesting accommodation?
No. The doctor is the only one that can decide if you need accommodation. I don't decide, you don't decide, the doctor decides. And if your doctor says you need accommodation, your employer has to make all efforts to make it happen.
And if it's too much, I don't want to do it, Lior, it's too much.
It may be something that an employer says, but the law expects the employer to try hard, even if it is difficult, even if it costs money. So it's not enough to say, hey, it's just too much.
Number three goes like this. Can an employer change your job description after accepting the position?
Well, it depends. Generally speaking, the answer is no if we're talking about a significant change. Could they make some minor changes? Sure. But if it's really a different job that they're giving you, that could be a constructive dismissal. But you also want to check your employment agreement. Does your employment agreement give your employer the power to change your job? If it says, we can change your job at any time, unfortunately, you've agreed to allow them to do that. So always look out for that employment agreement. And if you're not sure, you call me.
Rapid fire question number four goes like this. Can your employer revoke an annual bonus? What do you think, Griswold?
They cannot. If you relied on this bonus, you've gotten it in the past, it's now become part of your compensation, it has to be included.
Number five, can your employer implement tracking software, on a company device, right?
They can on a company device, so long as they only use it to track what you do during work hours. If it's beyond that, it's inappropriate. But if it is a company device, a company is able to use it.
We will get to one more rapid-fire question for the week, Lior. Ready to go? Here we go. Can an employer refuse a vacation request?
Yes. An employer gets to decide when you take vacation, and they can say yes or no, so long as they're not discriminating against you. That's a right an employer has.
Rapid Fire is done. So is the show for this week. Thank you so much for your contributions. Keep learning more. Simply go to the website, employmentlawyer.ca or pocketemploymentlawyer.ca, help at employmentlawyer.ca through email, and then that phone number, 1-855-821-5900. Thanks for tuning in. We'll catch you next time right here on the show.